So my presentation is about the duty of good faith and origin story, and I rewind even further than Gordon does. And so I'm taking us back to the 17th century. Sorry, sure, okay. So the duty of good faith and to act in the best interests of the company, as everyone knows, that duty, in some ways the place of that duty is unsettled in company law, but it's pretty ubiquitous across the world that there's that duty in some form in every jurisdiction. And the part that really is unsettled, like a lot of stuff in company law, amazingly unsettled, is really to whom is the duty owed? So is it the shareholders at any time, or is it the company as a separate legal entity? And to some extent, those two things are mutually exclusive, at least on the face of it. And also the other thing that's unsettled is the relationship of this duty of good faith and act in the best interest of the company to the other duties of directors. So the paper that this is based on uses history to provide some insight on those two questions. The core conclusion number one for the paper is that the duty of good faith is owed to the corporation as an entity, separate from its shareholders, and that the interests of shareholders are held in the entity legally separate from shareholders at any time. When we talk about the duty, we don't talk much about the use of the word interest of shareholders. So my kind of core argument is that the interests of shareholders aren't the same as the shareholders. They're their interests captured in the capital that's placed in the corporate entity that is separate. And core conclusion number two, that the origins of the proper purpose duty predate the origins of the duty of good faith. So the duty of good faith should be interpreted and applied subject to the proper purpose duty, and obviously the debate on purpose generally. But because Jennifer's only given us all 15 minutes, I can only talk about the first one. So I'm rewinding us back to the East India Company. And the East India Company, as I've argued elsewhere, being the first truly modern company, in the sense that obviously it wasn't incorporated through a general incorporation statute, but it had all the key characteristics that we would regard as essential for a modern company. And most particularly that exciting time in 1657 when the English East India Company had permanent capital that was separated legally and for accounting purposes through double entry bookkeeping from shareholders. Now, most people say that the VOC, the Dutch East India Company, was the first kind of modern company, but I would argue that actually they used Hanseatic bookkeeping, which was a different form, which didn't separate the corporate fund or the capital of shareholders from shareholders. So the East India Company did. So I think the English win on this one. And the members, and the other thing that I discovered, when I was really more looking at the form of the company, but wanted to explore more in this paper, was that members of governing bodies of all forms of corporation always swore an oath. So obviously they had obligations to comply with the charter, but they also swore oaths. And that applied to all forms of corporations. And the committees, which is the word confusingly actually that they use for directors, had to swear an oath on election that they and every one of them shall well and faithfully perform their said office of committees, meaning directors, in all things concerning the same. So immediately that wording starts to resonate a little bit, doesn't it, when you think about the modern duty. But this was all corporations, ecclesiastical, municipal, every corporation, and of course corporations dominated during this period. So really, what are the significance of these oaths? Well, the first thing is that oaths were not legally enforceable. They added moral obligations to pre-existing legal ones. And Pudendorf says that oaths in themselves, or said that oaths in themselves produce no new or distinct obligation, but come as a kind of accessory bond to an obligation already valid in itself. And for in the taking of the oath, we presuppose something upon the non-fulfillment of which we shall call upon our heads the punishment of God. So that's where oaths sat in relation to the legal obligations. So what's the significance of oaths? Well, the supporting nature of the oath didn't mean that the oaths were pointless, because as they said, all men except atheists believe that God punishes the violation of promises. But oaths were particularly useful when the fear of men did not seem effective enough, and when there was a risk of lack of confidence, unfaithfulness, ignorance, and passion. So let's sort of focus in on 1657 and the exact time when the English East India Company received a charter that gave it permanent capital, which you could argue is the period when the modern company emerged, in the sense that before that there wasn't permanent capital. And particularly people be familiar with John Evelyn, who was the other famous diarist, apart from Pepys. There he is when he was younger and older. Well, John Evelyn was fortunate enough to be an early investor in the East India Company at that time, and I won't talk about it here, but that was a good investment. People prospered, at least initially, if they invested in the East India Company. So he said in his diary on a particular date in December 1657 that he'd attended a meeting of the investors in the East India Company, and he talked about how there were new oaths, new orders, a mixed committee, and I think so reformed that if wars with Holland, which we fear, do not decompose us, it is likely to prove one of the most profitable, secure, and hopeful trades in Europe. Well, of course, he was right. So just focusing on what did he mean when he talked about a mixed committee first. Well, a mixed committee was actually you had a more diverse board. And of course, put this in the context of the times, that everyone was a rich white man, but they weren't all the elite rich white men that were the kind of previously had governed the major corporations of the period. So in the earlier part of the 17th century, the East India Company had been run by these founding elite merchants, and they had big shareholdings, and they just ran the company for their own benefit. But they couldn't keep doing that because they needed investment capital, because these voyages out to India were massively expensive, and so they had to draw in other investors. So that capital was provided by the small shareholders, and they became known as the Generality. So again, where we get the word general meeting from. In exchange for capital, generally, the Generality insisted on increased rights, including being represented on the governing body and having interested investors considered. So that's where the word mixed committee comes from, I think, but also probably led to the shift in the wording of the oath in the English East India Company to the general oath that was sworn by people taking on governing roles in all corporations. So here's the wording of the oath, and I just wanted for the second part really just focus on some of the words in the oath to sort of show you what emerged. So the first part there is the part that kind of was common to all oaths, but again, there's a familiarity to those words, isn't there? That you'll be faithful and true during the time of your place as governor. I'll focus in on it. We swear to be faithful and true during your time of your place of governor or deputy or trust, in the word sense of entrusted, nothing to do with, the more modern idea of trust, as one of the committees, directors, their word for directors, of the fellowship or company of the merchants of London trading to East Indies. So that was the wording of the oath that was very similar to every oath that a committee, director of a corporation swore. But, to be faithful and true, those wordings, good faith, very much related to the performance of the office or duty, which I think is quite interesting. Secondly, it was around complying with the charter, which contained the public purpose, if you like, of the corporation. So very much he was swearing to comply with the charter that had granted incorporation. But then the wording that, then we see the wording that was new, the new oath. The second part, and again, I'll focus in on that. You shall be careful to see and provide that an equal and indifferent hand be carried on in the government of this fellowship and in the affairs of all the adventurers, word for shareholders, that shall adventure or put in stock. So there it required that the shareholding committees, directors, who obviously controlled or were on the board, didn't favour their own interests above the interests of all of the stockholders or shareholders. And that wording was new because the investors had pushed through the previous 50 years or so to make sure that their interests were protected in the oath. So equal and indifferent hand, and just to sort of show why they wanted, or the investors said, well, we're not going to put money in unless you do this. In the earlier part of the 17th century, the controlling elite majority had actually, one of the ways in which they favoured themselves is that they'd made distributions in commodity.
Taking photos, but I can't turn it.
So I get another minute, right? So they made distributions in commodities. So instead of, in the commodities, of course, that was great if you were an elite merchant because you just distributed the commodities to yourself and then you on-sold them through your network of retail shops. But if you were like the younger son of a member of the gentry, you didn't want a whole lot of pepper arriving on the doorstep of the country house. So, so that wasn't fair in a sense to all shareholders, or they can purchase the commodities from the East India Company that were at rates favourable to themselves. So that again was another way in which they, the elite merchants had looked after themselves. So the investing shareholders insisted, and one of the interesting things was that voting rights weren't attached to shares at that time, they were attached to individuals, and of course that also gave the small investing shareholders quite a lot of power. So they were able to insist, both through their voting rights and also through their investing power, that the sale that they got paid in cash, not kind, and that the commodities, if they were on-sold, that they were on-sold at market rates, not special rates. Now the other wording of the new oath, the piece about the good estate, or 6 minutes, the good estate of the good estate of the adventurers in this present stock you shall favour and effect, that bit of wording, and also and that on an equal division from time to time to all the adventurers according to the proportion of their stock paid in. So those two pieces of wording. So there again, what I think that's showing us is that suddenly in 1657, remember these are new words, but essentially what you've got is a capitalist enterprise because you're getting a return on capital. And that's really significant when you think that prior to that, what used to happen is they'd go on a voyage or sometimes several voyages, and at the end of everything would be split up, and then they'd start again with a new set of voyages. But suddenly we have capitalism here because the capital's permanent, and then everyone gets a share of the profit or the excess that's distributed. So it's a really fundamental shift that's demonstrated in that oath. The other interesting thing about the wording, the governing body was expected to consider the affairs or interests of the shareholders rather than the shareholders themselves. And again, I would argue that's really significant. It might not seem a big thing, but it means that the shareholders come and go at any time, that idea, but actually the interests of the shareholders, which is the capital held by the company, well, that remains. So you're considering their interests held within the company as the capital. And I think it supports arguments that the sense that the duty was owed to the interests of shareholders rather than the shareholders themselves, which is again the way that you reconcile, is it owed to the shareholders, is it owed to the entity? Well, it's owed to the interests of shareholders in the company. Now, it might not be in many ways, when we think about our modern way of trying to widen the obligations that directors owe to include other stakeholders or other stakeholder interests. I think it's difficult if you look at the origins of this duty to run that argument, at least if you look at the origins of this duty. Now, just finally, and just to flick forward, so this idea of the mixed nature of directors, well, the case that's generally considered as the founding case on directors' duties, which I think, also traces through to, lots of jurisdictions beyond the UK, is of course Charitable Corporation of Sutton. And you see here also this mixed nature of directors in the sense that you'll see the wording there. I take the employment of director to be of a mixed nature. Now, everyone focuses on the second part of this, that committee men are agents. And one thing is, of course, the word agent didn't mean in 1757 when this was decided what it means there. So they weren't agents in a legal agent sense, but employ them in this trust. And again, trust, at least arguably even then, didn't mean when we talk about a trust there, it was more the idea of being entrusted with something. And then to direct and superintend the affairs of the corporation. But at the top there, that it's a mixed nature, partakes of the nature of a public office. So the idea that it was a public office did remain. So it was a mixed nature and it was a dual nature that directors had. And I think there is the foundations to at least argue that even though the duty of good faith might be owed to the interests of shareholders, there's something more there around charters and corporation statutes that could even override the duty of good faith. So I'm losing my voice. So I'll finish. Thank you.